Right. Good afternoon, everyone. I trust that there are some people that can see me in the way that I can't see them. But,
we can see you, Brian, so that's fine.
Good. That's excellent. Thanks, Lorraine. Right. I suggest that we start off. So firstly, welcome to LAW2020, online residential property, and the wonderful heading of Shape the Debate. So for those of you that don't know me, which is probably a majority, I'm Brian Hall, Managing Director of Lawshore Insurance, and we're very pleased to have been given the opportunity to sponsor and host the session today. So with me is Peter Dollar. Hello, Peter. And Lorraine Richardson. Due to unforeseen circumstances, David Keithley, who delivered two of the pre-recorded sessions, isn't able to be with us today. So we've got Lorraine, who is even more expert than David anyway, here to answer all of the questions.
So pleased to hear that one, Brian.
Yeah, so when you give the feedback that Lorraine was brilliant, I shall make sure that it all goes back to David. So,
absolutely.
In this session, you can put your questions to Peter and Lorraine and interact as the information's being delivered. And the whole session today is due to last an hour. We have a number of pre-submitted questions, so we'll run through some of those. And then we'll devote plenty of time as well to live questions. A recording of today's session will then be sent out by email in the next few days. So please keep a lookout for that and make sure it hasn't gone into spam or anything. Just to introduce the speakers. So Peter is a non-practicing solicitor. I think that means that she's so expert now that she doesn't have to practice anymore, but on the basis that practice makes perfect. So a freelance lecturer, a trainer, and a writer with over 25 years experience at practicing property law. She was a real estate partner at Denton's for 17 years and is now a full-time lecturer, trainer, and writer. Providing training on behalf of various organisations as well as in-house training for law firms and local law societies. She's a member of the Consultation Board of Practical Law Company and the Editorial Board of Landlord and Tenant Review. And we have plenty of questions coming up on landlord and tenant, so they should keep her well occupied. She's also site editor of the property law website, www.propertylaw.uk.net. So as part of LAW2020, Peter's sessions have included residential tenants' rights of first refusal under the Landlord and Tenant Act 1987 and building flats on top of existing buildings, so that there is plenty there of food for thought. I'm sure that you will have looked at the sessions already, but they'll also be available to continue to refer to after we've finished this hour. So Lorraine, in the meantime, is an experienced property solicitor and trainer. I'm reading words now. It says she's a popular conference and CPD speaker. I was going to say, great exaggeration there, I think, Lorraine. And
popular as David.
And was a partner and the COLP for her firm. She designs and delivers property and legal skills related courses and online materials, including conveyancing quality scheme training for the Law Society. She developed a skill for writing and delivering webinars and aims to produce work that's both interesting and accessible for the viewer. Major writer for the monthly update journal for practitioners, The Practical Lawyer. Lorraine standing in, as I said, for David, and I'm sure we will benefit from that. So the sessions that she'll be commenting on are the Section 106 agreements and community infrastructure levy, and various topical residential and property issues. So I think on that basis, without further ado, as I say, there were one or two questions that came in before. We'll run through some of those, and then we'll pick up on people's questions as we go along. So the first one, which I suspect, Lorraine, is probably one for you, and at the moment I think probably a little ambiguous. So whether the person that's asked the question is listening in order to clarify it a little bit. But could a wife allow her grown-up children to live in the matrimonial property gratuitously without the consent of the husband when the matrimonial property is registered in both their names?
Okay, thanks for that, Brian. Well, I think the technical answer to that question is, as we've said, it depends. I mean, I think implicit in that question is the fact that there appears to perhaps be some sort of element of conflict or lack of agreement between the joint registered proprietors, the husband and the wife. That's my understanding of where that question is coming from. Clearly, if it's the matrimonial home, if one of them isn't living there, possibly, presumably, perhaps the husband, in that scenario, then yes, it's theoretically possible. Of course it is. I mean, I think the question is really perhaps more around, if the husband isn't in occupation and he's a registered proprietor, would he be able to get the grown-up children out? Again, I think implicit in the question is the fact that perhaps the adult children aren't his. So there's quite a lot of ifs in that, packaged stuff into that question. But I mean, I think the sort of fairly, the straightforward answer is, yes, if he didn't agree, then she wouldn't be able to hold the children in there. But if the adult children got in there without his agreement, then to be blunt about it, he's probably going to need a litigator to get them out if they're living there, and presumably, and the husband and wife aren't living there. If she purports to give them some form of tenancy, the court may have to decide what would be the nature of their occupation. But I'm afraid, I hate to say it and fudge the first question really, Brian, but there's so many ifs in the question that it's a bit hard to give an answer. What I would say, as a non-contentious property lawyer, if I were confronted with that situation in practice, I would have no hesitation in involving a property litigation lawyer pretty early on to give the full advice to either the wife or the husband, or indeed the adult children.
Thank you. So yeah, Peter, the next question that we had, and timing is everything here because the pre-recorded session had to be done at a particular time, and life moves on in terms of various judgments and so on. But the decision in the Alexander Devine case, and whether that changes anything in relation to restrictive covenants, because that one's been developing and evolving over the recent days and weeks.
Yeah, absolutely, Brian. Yes, thank you for that. When I recorded the session, which was back in October, in the context of building flats on top of existing buildings, I did talk about the Alexander Devine case, but I talked about it in the context of the Court of Appeal decision, and we have since had the decision of the Supreme Court come through on that. This is a case on restrictive covenants, for those of you who haven't come across it. Basically a battle, if you like, between the Alexander Devine Children's Charity, which was basically a hospice for terminally ill children, and a developer of low-cost housing, which had basically constructed low-cost housing on land which was burdened by covenants in favour of the Alexander Devine Children's Trust. And basically the Supreme Court agreed with the Court of Appeal. They found for the Children's Trust, for Alexander Devine, but on slightly different grounds. But the thing that comes very, very strongly out of the Supreme Court decision is that the courts, and this comes out in easement cases as well as restrictive covenant cases, the courts really are not prepared to tolerate developers who just go off and develop completely in contravention of other people's legal rights just riding roughshod over other people. And the courts are simply not prepared to tolerate that. And the Supreme Court made it very, very clear in Alexander Divine that just because these houses got themselves built before the thing came before the court, that was not a good reason, basically, to allow the houses to be built, if in fact they wouldn't have been allowed if the thing had come before, actually, the Lands Tribunal, it would have been rather than the court, if the thing had come before the Lands Tribunal earlier on. So that's the thing that's coming through very, very strongly indeed. If you are a developer and there are third-party rights that you are going to contravene, whether they're restrictive covenants or easements, it's absolutely vital that you apply to the court or you talk to the person with the benefit of the rights. You don't simply ride roughshod over them, because the courts are not going to be happy. They are not going to find for you at the end of the day.
Thanks, Pete. Yeah, it was interesting to me as a layperson, because it's the first time really I've seen the state of the attitude and approach taken into account very much in terms of the decision as well. If you do it cynically, then tough, it will work against you. But
yeah, absolutely. And that's come through in more than one case. In the higher courts, in the Court of Appeal and in the Supreme Court during the course of this year. And in fact, in the Divine case, they keep talking about the developers' cynical conduct. That's the words that they use over and over again, which is a sort of a coded message. You know, we are not going to support people who behave like this, basically.
Okay, thank you. I mean, the case of Sparks versus Biden as well was referred to in relation to overage. And there's been a recent case in terms of new design. Peter, again, would you like to comment on that?
Yeah, well, Sparks v Biden was a case that came up again in my session relating to building flats on top of existing buildings in the context of overage. Basically, in Sparks v Biden, we find the developer basically trying to avoid paying overage, because basically the trigger for the payment of overage was the sale of the houses that the developer had built. And in fact, the developer manages not to actually sell any of the houses. Basically, he moves into one and lives in it as his own house, and he lets the other 7 on short-term tenancies. And poor Mr. Sparks turns up and says, "Where's my overage payment?" And Mr. Biden says, "What overage payment? I haven't sold any houses." Now, in Sparks v Biden, the High Court, very, very sympathetic to Mr. Sparks, who, it has to be said, is in his 80s. And he's relying on this money as his sort of pension fund, you know. And they imply into the contract a requirement for the developer to actually not only build, but also sell all the houses as quickly as possible. And that wasn't in the contract. Now, the interesting thing about U Design, it's a similar sort of principle. Basically, in U Design, it's a design consultant who's designed some flats actually in Singapore, and they get a success fee, if you like, when all the flats are sold. But in fact, the flats don't get sold because there's a recession basically in the market in Singapore. And the design consultants, rather like Mr. Sparks, say, well, you know, years have gone by, we want our money. And the court says, well, the trigger event hasn't arrived. No, we're not going to imply a duty to sell the flats. You know, that's what you agreed when you entered into the contract. And there you are, tough, basically. So it's a very interesting contrast. In the first case, the court being sympathetic to the person entitled to the overage. In the second case, the court being far less sympathetic. And I have to say, personally, I think the decision in U Design is actually the right one. I don't think you should be implying that because, you know, where a document has been agreed by lawyers acting for the parties, you assume they put in what was needed. And you don't assume that you go and add extra bits, just because that would be nice.
Peter, I was wondering with that, actually, if you don't mind me interjecting with
sure.
a question there, because as you say, the issue with the earlier case, as you say, was the elderly gentleman and the sort of sympathy for him getting his dosh.
Exactly.
And, the court said in new design, implying a term didn't, the design agreement was already heavily negotiated. It was very good.
Absolutely.
To apply anything to give it business efficacy because it had already got it. Do you think do you think that new design will have pursued their solicitors or their legal advisors for failing to put a long stop date in and have the crystal ball? What's your view? Do you think they might?
Depends on whether it was discussed at the time and so on. I mean, the annoying thing about Sparks v Biden is we really don't know what the discussions were that went on between the parties and their lawyers, and indeed between the parties themselves. We don't know whether Mr. Sparks said, look, and I really need this money because this is what I'm going to live on in my old age, sort of thing. We simply do not know. If he told his lawyer that, then maybe his lawyer might have thought. And Sparks v Biden, the contract was heavily amended. I mean, it went through more than 20 versions. And each party had a lawyer involved. So, what on earth they were doing to amend the thing, I don't know. But they didn't pick that particular point up. But it is just worth making the point, though, that in the last 5 years since the Supreme Court decision in Marks and Spencer's v BNP Paribas, the courts have been very restrictive about implying things into contracts that aren't already there. And basically, you should only be implying it if either it's so obvious it goes without saying, or the document simply doesn't make sense without it.
Okay.
Now, quite frankly, that's why I personally think Sparks v Biden is wrongly decided, because the contract did make sense without it. It's just Mr. Sparks had to wait longer for his money.
I think the one thing that we can be sure of in there is that if there was something wrong, it's bound to have been the solicitor's fault, because that's the way the world works these days. But right, I'll move us on, because in the meantime, we seem to be getting a number of questions and quite a lot of interest relating to the community infrastructure levy. So to lob one at you, Lorraine. Firstly, where's the responsibility actually lie for paying the CIL?
Well, I mean, David made this point in his excellent presentation, and I have to say, it's on a serious point, it's very kind of David to ask me to cover for him. I was very happy to do so today, and bless him, because as I say, he's not here for as you said, Brian, for unfortunate circumstances. And I have to say, as ever, David has done some searingly good notes to accompany his lecture. So I'm sure everyone will get a lot out of those. But yeah, a really important point to bring out of the community infrastructure levy, I think in particular for, residential conveyancers who aren't used to, necessarily don't come across this all the time. The really, really key thing to bring out of David's presentation here is that the community infrastructure levy, the responsibility to pay lies with the landowner. And that's really, really, really important. So if you are acting for somebody who is either perhaps acquiring a plot, from a developer where the CIL applies, or you are acting for somebody who's perhaps buying a plot that's got the benefit of planning permission and CIL, that somebody else has obtained and CIL applies, you've got to look very, very carefully at making sure the responsibility is, properly dealt with and the paperwork is properly dealt with in the contract, because the responsibility to pay lies with the landowner. And in his presentation, David pointed out a relatively recent case, of course, which made it clear that the regulations around CIL will be construed very, very strictly, and the appropriate notice regarding CIL wasn't served in relation to that particular case. The fact that the local authority, the landowner, everybody knew and really sort of seemed to accept the position. The fact was that the CIL notice wasn't properly served, and that, the court was really having sort of none of it. So it is really, really important to make sure all of the documentation is properly in place, but fundamentally that CIL liability is going to lie with the landowner.
Okay, thank you. I had a supplementary question to the first one that I asked you, Lorraine, in terms of the wife and the grown-up children and everything else.
Grown-up children, they're going to be a theme, aren't they? Fire away.
Yeah,
Mark.
I think so, because there's a whole question here as well. Could a wife reside in property jointly owned by her husband and her sister-in-law with a mortgage in place?
Well, again, it depends. I mean, if the property is owned by the husband and the sister-in-law, so if they are the registered proprietors, and if there is a mortgage over the property, and if the wife, the husband's wife, is essentially, she's in the position of non-owning occupier, the question, I think, as far as a lender will be concerned, is was the presence and existence of non-owning occupier wife declared at the time of the acquisition or remortgage, draw down the loan if the husband and sister-in-law already owned the property, and that scenario, then it would be then very much down to the legal representatives essentially acting for the lender there to make sure they got the occupier's consent form signed by the wife as the non-owning occupier, obviously to confirm that if the lender has to repossess the property for non-payment of the mortgage, that the non-owning occupier wife will vacate. If there isn't a mortgage, then again, a question then around would be, again, if there were ever a dispute, would then be around, well, what would be the nature of the wife's occupation of that property co-owned by her husband and sister-in-law, and whether she would seek to assert any sort of rights over and above, a mere license to occupy, or, would probably be as much as you've got. But what I don't know whether this is the hint in the question here, but I think what the Land Registry won't have any truck with is if the property is co-owned and the registered proprietors are husband and sister-in-law, the wife isn't going to be able to register a Family Law Act notice. She's not going to be able to register a Family Law Act.
Okay. Yeah. Thank you. So we'll loop back around to the CIL questions a little bit more in due course anyway, but to give you a rest for a moment, Peter, question, can existing tenants complain of derogation from grant, I should say?
I think this must be a question basically talking about where the landlord wants to build new flats on the roof of the building. And obviously, where the landlord does want to build on the roof of the building, generally the existing tenants are not going to be very happy about it, because the works are going to be noisy, it's going to be dirty. There you were, you bought this expensive penthouse flat, you thought you were on the top floor, and suddenly you've got, 2 more floors of flats going up on top of you and banging and all the rest of it, And I think there's no question but that the existing tenants are going to try very, very hard to find a reason to basically stop that happening. And I talked in my session about the tenants arguing that the landlord was in breach of their quiet enjoyment obligations. Now, derogation from grant normally comes along with quiet enjoyment. They tend to get looked at together in the cases. The difference between them is that with quiet enjoyment, where there are express rights reserved to the landlord in the leases, and very often there will be, the right to carry out works on the roof or in other parts of the building, the court will basically weigh the quiet enjoyment right for the tenant against the landlord's right to do the works. They won't cancel each other out. They will be balanced against each other. And they will look at things like, has the landlord acted reasonably? For example, have they minimised the noise and the dust and the inconvenience and so on? Derogation from grant, though, is slightly different. if the landlord has reserved an express right to build on the roof, then that right is effectively carved out of any kind of derogation from grant claim. Therefore, there can't be derogation from grant, if you like, on the part of the landlord, because they were entitled to do it.
Yeah.
If you see what I mean. So
I do.
the landlord may not have any right to build on the roof at all. But generally, in a modern lease, there's going to be a whole load of rights for the landlord reserved from those parts of the building that are not actually let on long leases.
Yep. Thank you very much.
The distinction there, basically.
Yeah. Thank you. One of my favourite pieces of legislation, I don't think, crops up next in terms of the Human Rights Act, and a whole question around whether a new building that overlooks an existing building can give rise to a claim in nuisance or under the Human Rights Act.
Yeah,
and I've come across the whole question of rights to light and everything, but I must admit I've never seen human rights in there.
No, and it's quite funny, isn't it? People tend to think, oh, well, if they're claiming that their human rights are infringed, they must be desperate. That's last ditch claim. Say, oh, my human rights have been infringed, But there was a case last year, I think it was, called Fearn, Fearn, against the trustees of the Tate Modern. And basically, this case, you may have seen it in the press. It was quite not amusing for the people involved, but it's quite amusing to read about. Basically, Tate Modern built a viewing platform 10 stories high and invited the public in to stand on this viewing platform and have lovely views of London. The trouble was that
you're just making me giggle already.
Yeah, I know. What the trouble is, human beings being what they are,
them to view.
The public came in, stood on the viewing platform, sometimes for hours at a time, sometimes with binoculars, peering in through the windows of some very expensive flats that already existed next to the viewing platform. So the viewing platform came later. So these poor people, they bought these really expensive flats with floor-to-ceiling glass windows and so on, and they were happily living in them. When along comes the viewing platform, suddenly they've got people peering into their living rooms and bedrooms, I say, with binoculars, taking photos, putting literally hundreds of thousands of photos that they've taken on social media, taken inside people's homes, making obscene gestures, and so on. And not surprisingly, the people owning the flats were upset. So, what could they claim? Well, I suppose they should basically have argued against it when the Tate Modern got planning permission, but they didn't do that. I don't think they actually quite realised how intrusive it was going to be at that point.
Or they thought they were exhibitionists, yeah.
Well, yeah, exactly. But anyway, so they came up with two arguments. Was it a nuisance? Could it be a nuisance to actually overlook somebody and interfere with their privacy? And in the High Court last year, they basically said, well, not in this case, but potentially yes. Went to the Court of Appeal this year, and the answer was no. And on the human rights claim, basically neither the High Court nor the Court of Appeal felt that there was any infringement of human rights. So, and indeed, it has to be said, a complete and utter lack of sympathy for these people who bought these flats, spent literally, several £1 million buying these flats, in central London. And the court's attitude was, well, put up some curtains if you don't want to be stared at. Which,
I think the High Court decision is worth a look, because the court, I think, if I remember correctly, Peter, they were sort of, and again, the sort of point that these flat owners were making was that, well, we bought, as you say, we bought these sort of, penthouse, marvelous, terribly expensive flats. These floor-to-ceiling open windows were part of the design feature of property. And all that. Frankly, I would have had no hesitation in looking at it and thinking, I need some nets up there. But but the court was sort of positing, all the possible things that these people could do. You say putting nets up, and could they sort of stick a bit of frosted sticky back plastic on the windows of these multi-million-pound flats?
Exactly. Yeah.
I mean, as you say, it's people involved, but there wasn't really a great deal of sympathy, was there? And I frankly, if I'm wandering around in my pants in my multi-million-pound flat with my floor-to-ceiling windows, do you know what? I might just have worked that out when I viewed the property, if I'm really honest. But
yeah, I just don't understand why you use the term if, Lorraine. You mean when you're wandering. Yeah.
Pants, yeah.
Very odd though. Years ago, when I was in practice, I had an office that looked out directly onto a block of flats, and they were only literally a few meters away. Their windows and our windows, and lots of them didn't have any curtains. And the things that we used to see, people would come in and take all their clothes off or whatever. It was as though they just did not realise that we were there and that we could see them because they were on the 5th floor or the 6th floor or whatever. It didn't seem to occur to them.
Well, actually, that's a completely different matter, but as a matter of conduct, actually, that's happened relatively recently, Brian, because, again, as Peter said, we got, and there was an example, there was a conduct issue quite earlier this year, I think, where there were two law firms who've got, quite, adjacent windows in the city, and one, somebody in one firm looked into the window of a lawyer in the firm across the road and found him doing something a little unsavoury that, as a matter of conduct, he should probably been doing, and he got a bit of a pasting for it as a result. So
yes, make sure you do invest in blinds. I think is the answer there. So that, right. So looping back to the community infrastructure levy again. And Lorraine, I think, get things down onto a serious note here. So, are there any particular risks that need to be avoided? Are there any views in terms of steps that conveyancers should take if CIL applies in their region, their locality?
Yeah, I mean, well, I think there are, a sort of couple of things really that I think are important, and I'm definitely looking at this from the perspective of the sort of what I might call the residential conveyancer, sort of general practitioner who isn't perhaps a commercial property lawyer who's not as au fait with the full workings of CIL, because that clearly is one of the risks. And funnily enough, there's probably a risk if the CIL doesn't apply in your area. But what I think conveyancers need to be really, really clear about is that, as frankly with Section 106 liability, if the local search and you're acting for a buyer, for example, who is buying a plot from a developer where the community infrastructure levy applies, if, as frankly is often the case, the developer solicitor is a little, how might we say, scant in their responses to your inquiries around, CIL liability for payment. I mean, frankly, it's not difficult. If you're a developer, you're going to have evidence that you've paid something, and you're going to have something in writing from the local authority, either a receipt or that says, "Dear developer, thanks for your slice of money." That, in my opinion, is not a difficult thing to produce. So if the developer's solicitor sort of prevaricates or gives rather a poor answer, or you're just not satisfied, well, do remember that all local authorities have their rather gloriously named Section 106 officers, poor souls in the local authority whose sole job, bless them, is to monitor and manage these payments. All of this stuff's a matter of public record. So if you're acting for a buyer and you aren't clear either about CIL liability or indeed whether or not it's up to date, then you should, in my opinion, be contacting the local authority directly to satisfy yourself, because that sort of arcs back to the earlier point that CIL liability runs with the land if nobody else is going to pay it. So your owner could absolutely be liable to pay that money. And of course, the sort of forward-looking point and the one of the real risks is making sure that if the CIL is paid up to date, perhaps at the date of the transaction, but there is a sort of future payment that's yet to be made, i.e. a future liability that hasn't yet fallen due, because they often then you do need to make sure you get an indemnity in the transfer. I would suggest at the very least from the developer to make sure it's paid. But be very wary if you're not familiar with CIL and you're acting for a buyer where the CIL applies to really button that down.
Okay, thank you. And while we're talking about risk, someone's raised the whole question of the movement towards electronic signatures and using the HMLR signatures. Do you want to just pass a brief comment on that?
Yeah, sure. I mean, the Land Registry sort of slipped out their willingness to, firstly, I mean, we had sort of two stages, really. The Land Registry said, I think in May, that they would accept Mercury signatures as on transfers, which essentially, and they've got sort of a step-by-step process specified in Practice Guide 8. So anybody that, is dealing with this needs to be looking very carefully at Practice Guide 8 now. But the Mercury signatures are essentially a scenario where, because conveyancers in particular weren't able to see their clients during lockdown, we were having, a perceived difficulty, at least I should say, really, with getting documents sort of signed and witnessed, particularly the transfer. So the Mercury signature, by and large, is a situation where the document is usually emailed to the client. The client downloads the signature page, signs the signature page in wet ink in the presence of a witness, and then you scan that or photograph that page and send it back to your conveyancer with the document. So you've got a complete document that goes back, and that scanned page is then acceptable by the Land Registry. So that's the Mercury signing method, which was accepted in May. But then the Land Registry slipped out in a blog on July the 27th that they would accept witnessed electronic signatures, and you need to be looking at section 13 of Practice Guide 8 for this. And that's a sort of step up from the Mercury signatures, because that's a process where the conveyancer, the seller's conveyancer will essentially, have access to an IT platform, and you've got sort of a two-factor authentication where a document is sent to, typically it's going to be the seller when we're talking about transfers, and the seller essentially will electronically verify that it's them. They will, however that particular platform enables them to sign, whether it's scribbling their name sort of electronically or whether it's sort of digits and letters, they will sign, and then crucially the witness, who must also still be present with them, will electronically confirm that they have witnessed that event at the same time. But the key thing really, I think there's 2 points really. So the Land Registry crucially will accept transfers signed in that way. So that's a big deal. The two key things, firstly, I think that practitioners need to grasp is firstly that the signatory and the witness still need to be together. So that process needs to happen at the same time with the signatory and witness together. In fact, there's 3 things. Secondly, both conveyancers, both the seller and the buyer's conveyancer, need to verify and confirm that they are happy to deal with the process in that way, because crucially, the third point I would suggest is probably the most important thing for buyer's conveyancers, is the buyer's conveyancer, when they are then making the application to the Land Registry with that transfer that's been signed this way, the buyer's conveyancer, is then happy to confirm to the Land Registry, to the best of their knowledge and belief, I think it is something like that, that the steps in Practice Guide 8 have been complied with. So the crucial point is the buyer's conveyancer is verifying that the seller's conveyancer has adopted this process in Practice Guide 8. So there's that. So that, I think, I think that's going to take a bit of time, to be quite honest, but widely adopt. I think, big city firms that are doing international deals all over the shop you know, who've got very sophisticated, you know, IT platforms, etc., etc. It's not going to be a big deal for them, but because you need both conveyancers to agree, you've really got to have grassroots conveyancers accepting this. And again, my view for what it's worth at the moment is, I think conveyancers are going to be wary, A, because of giving that certificate, and B, that there's the whole issue of hacking and fraud.
Yeah. So over time, but for the moment, everybody's got to agree and everybody's got to be comfortable. So yeah, I'll move on a little bit because there's lots of questions still to try and work through. So Peter, a question that I find intriguing anyway. Got a mixed-use building and you've got part of it residential, part of it commercial. How do you actually calculate the split between the two occupations, and in particular then what you do with common areas?
Well, this is basically relevant to the Landlord and Tenant Act 1987, Residential Tenants' Rights of First Refusal. And the important thing here is that a building is only actually within the 87 Act, so that the landlord is restricted from making a disposal without complying with the 87 Act, is actually only within the Act if more than 50%, if 50% or more of the building is used for residential purposes. So if you can possibly measure it and work it out such that over 50% is used for commercial, even if it's only 50.0000001%, that's it. You don't have to comply with the 87 Act. And obviously, if you're a landlord, you really do not want to have to comply with all the fiddly stuff in the 87 Act. So, how does it work? Well, it's internal floor area, and what you do is you basically calculate the floor area of the building as a whole, and then you deduct from it the area of the common parts. And common parts for this purpose is any part of the building shared between two residential properties, so two flats, say, any part of the building that's shared between two commercial units, or any part of the building that's shared between residential and commercial parts. So if it's shared, it doesn't matter who it's shared between, you deduct it, and then you work out how much residential you've got and whether it's 50% or more of the space you've got left after deducting the common parts. Now, I have had it argued, no, you deduct the bits that are shared between the resi part, you deduct that from the resi part, and that's wrong. You deduct all the common parts from the whole before you work out the individual resi and commercial that's left. And that obviously can make a huge difference because, if you think, for example, of a number of shops with flats above, for example, you might well not have any shared space between the shops. They may be individual units with no shared space. But if the flats are upstairs, there might be an entrance hall up there or a staircase or something. And that is basically going to mean, or it may mean, that although it looks as though the proportions are 50-50, in fact, the commercial proportion is slightly more than 50%. And obviously, that is what the landlord ideally would like. And I would always advise a landlord, if there's any kind of possibility of getting around that 50% figure, to get a surveyor in and get it properly measured. Because the cost of doing that, if you can get your residential down below the 50%, you're going to save so much time and trouble and delay and money and so on, that the cost of having a proper measuring exercise done is minuscule in comparison.
Right, and otherwise you then move a wall about a foot to one side to actually reduce the size of the residential and increase the size of the commercial.
Well, that is something you could do. You do have to be slightly careful, though. There is a case, actually not in the context of the 87 Act, actually in the context of collective enfranchisement under the 1993 Act, Basically, there was a restaurant on the ground and basement floors, which obviously unarguably is a commercial use. However, in the basement of the restaurant, there were some rooms, and they were used as bedrooms by some of the staff. So if the barman or the chef or whoever was working late, it got to 2 or 3 in the morning, and they closed the restaurant, and they basically then went and doffed down in the bedrooms to save having to go home late at night. And the court held that those bedrooms were residential space. So although the overall thing was a restaurant, because that part of the space was used for resi purposes, it fell within the resi part of the building. And in that case, it actually brought the building within the 93 Act. It was those bedrooms that did it. So
when is a bedroom not a bedroom? Like when is Japanese knotweed not Japanese knotweed? So I'll move us on a little bit because I'm mindful of the time. But Lorraine, somebody's asked questions about whether it's mandatory for firms to follow the Law Society practice notes.
Well, I mean, the short answer is no, but there's a lot, the Law Society, is the professional body of solicitors, of course, and they do put out an enormous amount of very useful content. They've recently revamped their website, and just be careful because actually they do seem to have shifted quite a lot of content around a bit. So you do need to actually, do need to go on a little bit of a find now. But as I say, on a serious note, and as David, put in the update, they've updated the practice note on property fraud, which frankly must be required reading for all conveyancers. And I think the bottom line is around the practice notes is it mandatory to follow them? Well, no. But if we ever had a negligence claim brought against us, or worse still, a court case, at the end of the day, the practice notes set out, the clues in the title, best practice for us to follow. And I therefore think, if as a firm or a practitioner we weren't following the advice from our professional body, that's not going to augur particularly well in relation to the case against us. Now, equally, it's not going to be, I suppose, a defence to say, well, I did what the Law Society said, and therefore I must be in the clear. But no, so it's a long-winded way, Brian, of saying no, it's not mandatory, but they do set out best practice. They are from our professional body, and therefore, if we depart from, and I think there's probably a distinction here, isn't there? If we depart from what they advise us or suggest, they always say not advise actually. If we depart from what they suggest, then if we can demonstrate from the file our thinking and the reason for that departure, then that's probably, defensible. But I think the key for conveyancers here, if we put it on our file, I would liken it to, you're working out in a maths question in your O-levels when I'm so old, O-levels, show you working out. That's what our regulators, that's what our insurers, that's what people, why did you reach the decision you reached?
Why did you do it that way?
Absolutely. Yep. If we depart and we evidence on the file why we departed, I think that's a position we can argue and substantiate. That I think is quite a different scenario from a firm or a practitioner just saying, don't know, didn't even exist, didn't have a clue. That's probably going to be an indicator of a much greater level of concern about how they do their work anyway.
Okay, thank you. All right, one that actually is occupying our minds on the insurance side quite a lot at the moment as well, Japanese knotweed. There used to be this wonderful situation of there being a yes or no answer to the presence of Japanese knotweed, and now people have been given this get out of jail clause of they can now answer, I don't know. Lorraine.
Yeah, this follows on from, and again, David's put it in his excellent notes, this follows on from the Law Society's updating of the Property Information Form, which right now sort of seems like a million billion years ago, doesn't it? Took them 2 goes in swift succession, mind you.
Yep.
Put out something that, having just said follow their practice, seemed to be sort of peppered with errors. But I think, and as you quite rightly say, Brian, we've now got for the sellers on the Property Information Form, roundabout question 7, I think, we've now got the Japanese knotweed question, is the knotweed at the property yes, no, or not known? As you quite rightly observe, it's the not known that's the zinger. But the real zinger, and this is what firms might not have looked at, is actually the Law Society's guidance on the property information form. I think this is what's interesting for firms to think about, because the guidance, in my opinion, is quite a strange mix of view and opinion. Sometimes it seems to be expressed to talk direct to the seller and direct to the buyer. Sometimes there's the voice is you should do this and you should do that if you're the seller or the buyer. And then other times it doesn't. So I think it's quite a strange mix. Inevitably, as is often the case with the law soc, the guidance is longer than the form itself, of course. I think firms need to think quite carefully, actually, about, on a sale and a purchase, the extent whether they might consider sending the Law Society's guidance to their clients with the property information form. I accept there may be an argument that says, that's going to raise more questions than it answers. But the zinger really with the knotweed don't know, Brian, is the fact that essentially the Law Society has suggested in its guidance on the PIF that if a seller, and this is where they're writing to the seller, and it sort of says, words to the effect of, you must be absolutely certain that there is no knotweed to write no. And if you're in any doubt, put not known. So the key then, and the commentary and the follow-on from that really is whether that seller putting not known, then really shifts the onus to find out whether there's knotweed onto the buyer, which then can either lead the buyer, and then you as the buyer's conveyancer, should be flagging the implications of not known to the buyer. I think you probably should, i.e. suggesting to the buyer that they might need to satisfy themselves that it's not there, maybe get a knotweed specialist in. And of course, the corollary of that always is, well, should we be declaring a not known on the PIF to our lender? And again, I think probably to be on the safe side, conveyancers don't want to hear it right now, but I think the answer to that question should, to be risk averse, you should probably be declaring a not known to your lender as well.
Yeah, that's where quite a lot of the pressure is coming from at the moment in terms of our inquiries, is the lenders wanting to be comfortable. So yeah. So
just actually as a matter of interest, Brian, and to turn that route, then how does Law Sure Insurance fit into the knotweed scenario in terms of interest products and so on?
We can provide an insurance cover for usually a period up to about 5 years and a level of up to about £20,000 worth of costs for the cleanup of Japanese knotweed if it's there and it wasn't known about, or that it was known about and it's been properly treated and everybody hopes it's gone away as a problem. But as I say, we're also seeing now lenders looking to inquire whether it's available on a scheme basis, or indeed various solicitor firms looking at trying to put an automatic scheme, an automatic cover in place for the not knowns.
So does the not known cause you a problem as an insurer?
No, the answer yes gives us a problem. We're tending a little bit, like you said, to take the not known as the safe option for those who would otherwise answer no, because no really does require you to be categorically sure that thing growing up in the corner of your garden couldn't possibly be Japanese knotweed, or indeed Bohemian knotweed, or hybrid knotweed, and all sorts of other things. So
that's the interesting thing, because again, I think another thing coming out of this for conveyancers, and something else that concerns me a bit is because the point you made earlier on, Brian, because everything's always our fault, because we're the only people properly insured if something goes wrong, is the fact that everybody fixates on knotweed. But actually, I think we should be saying knotweed or other, dangerous / invasive plants, because knotweed isn't. It's the superstar of dangerous nasty plants, but it's not the only one by any means. So I think from the conveyancer's point of view, we need to perhaps be saying in our reports to our clients, look out for, or get a proper survey for knotweed or other invasive plants, because I can guarantee when something else hideous comes along that's not knotweed, that causes damage or problem with the property, the client and the lender, they're both going to say, well, you didn't tell us, solicitor, you didn't tell us, so it's your fault,
Yeah. Well, we've certainly been pushing insurers. We tried with the sort of any invasive species, but we have managed to push insurers to make sure they cover all the knotweeds, because Japanese knotweed was but one type.
Exactly.
But you're right, things like bamboo and so on can provide just as many problems. So, right, I'm very mindful of the time now, and the questions are still coming in, so I'm going to start and pick and choose a little bit. So, back to building flats on top of an existing building, Peter, and falling foul of the 87 Landlord and Tenant Act. Is there anything more we need to add there?
Well, yeah, where you're building flats on top of an existing building, the difficulty is if the landlord basically wants to grant a lease of the roof space, the loft space, or even the subsoil of the building to a developer to allow them to build new flats. The problem is, if the building falls within the 87 Act, then granting that lease or entering into an agreement to grant that lease will be court, which means that before you can grant the lease to the developer or agree to grant the lease to the developer, you are going to have to offer it to the tenants first. You're going to have to wait a minimum of 2 months, and so on and so forth. And very often, of course, the tenants are going to be as obstructive as they possibly can, because they don't want people building flats on top of their nice, quiet, pristine building. So, how can you get round it? The only way, basically, for the landlord to get round it, if the existing block of flats falls within the 87 Act, is basically not to make what's called a relevant disposal. In other words, not to grant a lease or agree to grant a lease. There's nothing to stop the landlord, for example, entering into a building contract for the construction of the flats. That wouldn't be caught. There's nothing to stop the landlord entering into a joint venture agreement, for example, with a developer, whereby the developer has a license to come in and build the flats. That's absolutely fine. The point is, once the flats are built, then they can be individually leased. And that's one of the exceptions to the 87 Act. That is not a relevant disposal as defined. So basically it's granting a lease or agreeing to grant a lease over space, airspace, etc., space which does not yet constitute a flat or flats. And a flat or flats basically means something that is suitable for living in.
Right. Thank you very much. Right, I'm going to exercise the chairman's prerogative and bring things to a close. I shall make sure that to the extent any of you feel that you've got questions that haven't been answered, if you direct them at the solicitors group, I'll make sure that they do get picked up. But I think for the moment we've run out of time. So if I can just say thank you for actually attending the Shape the Debate session today. I've enjoyed hosting it. So, and if you do have anything that relates to any insurance queries and moving of risk from solicitors across to insurers, then don't hesitate to let us know. But in the meantime, thank you very much indeed to our experts, Peter Dollar and Lorraine Richardson. I'll definitely feed back to David that you did a brilliant job there, Lorraine. So, don't forget to join the solicitors group LAW2020 online community on LinkedIn, because the debate will, I'm sure, carry on there after this session. And it'll also enable you to be included in a variety of exclusive offers and future events. As I mentioned at the beginning, a recording of the Q&A is available and will be sent out by email within the next few days. So there's still time to re-watch or watch again the pre-recorded content, because when it was sent out to you, there was a time limit. So you'll typically still have some further days. To To book in live sessions, then just go to thesolicitorsgroup.co.uk, where you'll also find the online exhibition. Exhibition's open to anyone to visit. And if you book the entire event, you can claim your free 1-hour CPD webinar from the 2020 Distance Learning Catalogue. I'm reliably informed worth £35 plus VAT. And you can also,
if there being a catalogue, Brian.
I know, you can also visit the exhibitor profile, but there'll be feedback forms after the event, so that if you have nice things to say about us all, then please fill them in. If you don't necessarily have anything nice to say, then the trigger will be that if you complete feedback forms, then in due course you'll receive the CPD certificate. So thank you all very much indeed for your time, and I hope you've enjoyed it as much as I have. Many thanks. Bye, everyone. Bye.